regard to the sequestration motion, the motion is granted to the extent that all non-family and non-experts are sequestered.
Your Honor, can I confirm whether or not our case agent will be allowed to remain?
Sure, case agent, you're allowed to have a case agent.
Thank you.
Anything further before the jury comes?
Please, Court. Good morning. Judge, when the court has an opportunity to review those documents from Mr. Rutherford, I understand that that witness may testify today. The defense would like to review them.
All right.
With respect to the court's order of October 11th, there has been some concern expressed in my consultations with the solicitor that the permissible electronic coverage may intrude on private conversations between members of the defense team and between members of the defense team and members of the prosecution team. I have a serious concern about that. Apparently,
What are you talking about?
the October 11th in which the court allowed recordings in the courtroom did not address the audio recordings, which came to our attention yesterday, that conversations between me and the solicitor may have been overheard. We expressed concern to the clerk at that time, and I'm not sure that that has been resolved, but I would ask the court to ensure that private communications among members of the defense term and counsel table, as well as private conversations between the solicitor's staff and the defense team in the process of court proceedings be kept confidential.
So ordered.
Your Honor, the defense requested permission of security to bring into court for demonstrative use the uniform and assets provided by the North Charleston Police Department that were worn by Mr. Slager on April 4th, 2015.
Is that opening statements or during the course of the trial?
Both. That equipment would not include any firearms.
It says the statement.
I don't know what the issue is.
The security said that it would not be permitted to be brought into the courthouse unless the judge ordered it.
And when was that issue brought to your attention?
When we attempted to bring it in
When was that?
this morning.
You're permitted to bring it in.
Thank you. The issue of bond arose yesterday, Your Honor, late in the afternoon. We have available a representative from the bonding company if the court wishes to make inquiry.
All right. Sure. You make inquiry as to why he's here, and we'll see if that's sufficient. You make inquiry as to why he's here and tell me all about it.
Would you like my oath or just?
No, sir, that's fine.
Yes, sir. Did I see a copy of the bond? Thomas Lowndes, is that correct?
It's Thomas, yes, sir.
Tom Lowndes, speak loud enough for the court.
Yes, sir.
Please. Are you familiar with the bonding procedure that took place before this court with respect to the state charge of murder against Michael Slager?
Yes, sir.
As a result of that hearing, did you provide the clerk of court with an assurance to have Mr. Slager appear at any court proceeding?
Yes, sir.
Was that done in accordance with the Palmetto Surety Corporation?
Yes, sir.
And are you a representative of the Palmetto Surety Corporation?
Yes, sir.
And were you, in addition to the surety, did you ensure that Mr. Slager abided by all conditions of the bond set by this court?
Yes, sir.
Has Mr. Slager, to the best of your knowledge, violated any conditions of bond?
No, sir.
Is he currently under bond?
Yes, sir.
Are you aware that his bond will be surrendered to the court upon swearing of the jury?
No, sir.
Are you aware that every bond that you issue, your commitment to the court ends upon the swearing of the jury?
No, sir.
Well, it does.
Yes, sir.
So, knowing that, if you now know that, have you, in consultation with other members of your corporation, agreed to maintain the risk that your surety has undertaken to the tune of $500,000 to ensure that, to this court, that Mr. Slager will remain under the conditions of bond and will report to the court as directed by the court?
Yes, sir.
Knowing that if he fails to do that, you and your corporation will be held accountable for $500,000.
Yes, sir.
And you agree to do that?
Yes, sir. We have had no problem, Mr. Slager.
Kindly answer any questions that the prosecutor or the court might have.
Anything for this?
No, sir.
All right, he will remain out on bond.
All right, thank you very much.
Your Honor.
Thank you, Your Honor.
Anything further?
Nothing from the state, Your Honor.
Judge, we would have nothing further other than to ensure that the record is complete, that we would urge the court to consider those matters that the court has already ruled upon. Mr. Slager will abide by those rulings, but we wanted to ensure that we properly notice the court of our exceptions to the court's rulings.
All right. Ready for the jury?
Yes, sir.
All right, you may go to the jury. morning.
Good morning.
Welcome back, ladies and gentlemen. If you all will stand at this time to be sworn.
Please raise your right hand. Do you swear or affirm that you shall well and truly try and a true deliverance make between the state of South Carolina and the defendant at the bar, whom you shall have in charge, and a true verdict render according to the evidence and the laws, so help you God? Please indicate by saying I do.
I do.
Please be seated. Any juror cannot accept this oath, please stand now. Please let the record reflect all jurors seated.
Ladies and gentlemen, we are about to try, in this case, the case of the state versus Michael Thomas Slager. Before we begin this trial, I want to tell you that this trial probably will be different from what you might expect. Many people do not have the chance or the opportunity to attend court sessions as you're doing now. And they may think from watching television or movies or reading books that trials are always full of high drama, intense action, and riveting circumstances. While all of these things may be true at times, this trial is not for entertainment like those things, like they often are. This trial is a fundamental part of our democracy. It is a search for truth in an effort to make sure that justice is done between the parties before the court. In searching for truth and making sure that justice is done is often slow, deliberate, and repetitive, the opposite of what you may have seen on television, in the movies, or read in books. This courtroom is a place of honor dedicated to the protection and preservation of citizens' rights through what many have called the greatest justice system ever created. The attorneys appearing before the court and before you are advocates for the parties they represent. But first and foremost, they are officers of the court. They are sworn to uphold the integrity and fairness of our judicial system and to help you in this search for the truth. You should expect from them to be professional, competent, and ethical in the representation of the respective interests that they represent. Likewise, you are also expected to be professional, reasonable, and ethical. Thank you for accepting this important responsibility of jury service and for your contribution to our judicial system. Now, what I now will say to you is intended to serve beyond what I've just said as an introduction to the trial of this case. These remarks are not a charge on the law in this case. I will instruct you on the law applicable to the case at the end of the trial and before you retire to consider your verdict. This is merely an explanation of the procedure that we will follow in the trial so that you may better understand what is happening. Now, with regard to taking notes, there are two theories of thought on that. There are several theories of whether jurors should take note. One line of thought is that if you're focused on note-taking, that you may miss certain key indicators in observing the testimony of witnesses. You may get so caught up in writing things down that you miss things that are important. Also, some people are greater note-takers than others. So in fact, you can take notes if you wish, and we'll give you a notepad. But you should understand that the fact that you may take a note is given no greater credence than someone who may not take a note. So we'll have, if you're interested in note-taking, the bailiffs will provide, you'll indicate that to the bailiff, and they'll give you a notepad with your names on it and a procedure through which we'll keep track of those notepads. defendant is charged by an indictment filed in this court with the crime of murder, the elements of which will be explained to you later. Now, this indictment is simply the charge that brings this case into court, and it is not in any sense evidence of the truth of any of the allegations it contains. The defendant has pled not guilty to this indictment. The state, therefore, has the burden of proving each element of the indictment beyond a reasonable doubt. And it will be your duty as jurors, ladies and gentlemen, to decide whether the state has or can meet that burden. Your purpose as jurors is to find and to determine the facts of this case. And out of all the folks who are summoned to appear here Monday morning, out of all the folks who live in Charleston County, out of all the folks who live in the state of South Carolina, only those of you who will deliberate in this case can determine the facts of this case. If at any time I make any comment regarding the facts, you must disregard it, because you, the jury, are the sole judge of the facts of this case. You are to determine the facts from the testimony that you hear from this witness stand, together with any other evidence introduced in court. It is up to you, and will be up to you, to determine the inferences which you feel may be properly drawn from the evidence presented. It is especially important that you perform your duty of determining the facts diligently and conscientiously, because ordinarily there is no way to correct an erroneous determination of the facts by a jury. Now, just as you are the sole judge of the facts, on the other hand, and with equal emphasis, the same law that makes you the judge of the facts makes me the judge of the law. The law as given by this court to you is the only law that you may consider. You must accept as correct the law that I give you at this time during the trial and in greater detail at the end of the trial. And your job as jurors is to take the facts as you find them to be and apply the law as I give it to you from the law. You find the facts from the testimony and the other evidence, then deliberate and reach a verdict consistent with the solemn oath that you just took. Now, until I tell you that it's time to do so, you may not begin deliberating with each other. In other words, you may not discuss the case with each other, with anyone else, or allow anyone to discuss it with you or in your presence. That includes not only your fellow jurors, but friends, family members, or anyone involved in this case or not involved in this case. If you see anyone involved in the case that might want to speak to you, you should simply refrain from having contact with them. And during the deliberations, you may discuss this case only in the jurors with your fellow jurors who have seen and heard the same evidence, seen and heard the same law. You must decide this case based solely on the evidence presented in this court. This means that during this trial, you must not conduct any independent research about this case. You are not to attempt to find out information from any source outside of this courtroom. In other words, you must not look at reference materials, search the internet, websites, or any other electronic tools to help you. You may not use computers, cell phone, laptops, smartphones, or any other technological tools while you're in the jury room, or to use them outside of the jury room to find out anything more or anything additional about this case. The thought behind that is that the jurors who deliberate and decide the case must be those who have heard exact evidence, those who have heard exact law, and those are on that basis that you'll take that to enter into discussion or deliberations at the appropriate time. If you become aware of any juror in violation of these instructions, please inform the court immediately. And it is important that you keep an open mind and not decide any issue in this case until all the evidence has been presented and the parties have made their closing arguments and I've instructed you further on the law. It is your solemn responsibility to determine the guilt or innocence of the defendant. And as I indicated earlier, your verdict must be based solely on the evidence as is presented to you during this trial, applying the law as I instruct you. In just a moment, the solicitor will make an opening statement in which the solicitor will explain to you the issues in the case, or at least what the solicitor thinks the issues in the case are. The attorney for the defendant may also make an opening statement, though he is not required to do so. You should remember throughout the trial that what the attorneys tell you during their opening statements or through questions asked of witnesses or arguments made to you, what the attorneys tell you is not evidence. And what they tell you during the opening statement, it will be their contention as to what the issues are. From time to time during the trial, you may hear counsel indicate that they want to, or they have a matter of law, or may want to approach the bench. If that occurs, it may be necessary, or will be necessary in some instances, to excuse you from the courtroom as we discuss these matters. In determining the facts of this case, necessarily you will have to weigh the credibility of witnesses, that is, the believability of witnesses. It is my responsibility as a matter of law to rule as to whether certain testimony is admissible or not, but once that testimony is admitted, whether or not you believe it is solely for you to determine. I certainly want you to encourage you to give strict attention to the testimony and the evidence presented. We will take breaks as necessary to keep you as alert and fresh as possible. In addition, later in the process, I'm going to appoint one of you to serve as the foreperson of the jury. That person will have the responsibility of serving as the spokesperson for the jury, of presiding over the jury deliberations, and of completing the verdict form representing the unanimous verdict of the jury. In order to preserve everyone's rights, I'll give the parties an opportunity to object to anything that I've said. Any objections?
No, sir.
Yes, sir.
Madam Solicitor.
Thank you, Your Honor. May it please the court. Good morning.
Good morning.
Before I get started, let me reiterate one thing the judge said. Thank you all for being here. Y'all saw how jury selection works. We know this isn't an ideal situation for y'all to be in, that you're missing out on work and family and things like that. We're going to do everything we can do to keep this as efficient as possible. But one thing I want you to to realize when you see me looking at my watch, I had to get a new watch with bigger numbers on it because having that issue. Or looking at that clock, either us or the defense, it's not because we've got somewhere else to be, that I'm getting my nails done, or I have a lunch date. It's because we've got a bunch of witnesses lined up for y'all who also have other things to do and jobs and things like that. And we want to keep them as on track as we can. So we're trying to figure out who's next, where they've got to be, and what's going on. So we want to keep this thing moving as efficiently as we can. The judge is right. This isn't Hollywood. If it were Hollywood, I don't think I'd look like I look. This is real life, and it's not going to always be exciting and exhilarating. We have things like chain of custody that are boring, but are required under the law for us to do, to put in evidence. So, again, thank you for your sacrifice. This really is the highest calling for a lay person, someone who's not in the military, to serve your community. So with that, let's talk about this case. And I want to start with something that I suspect, as the evidence unfolds, that you might think and maybe might not want to say, but I'm going to say it. And I'm going to put it right out here. If Walter Scott had stayed in that car, he wouldn't have been shot. If Walter Scott had not resisted arrest, he wouldn't have been shot. He paid the extreme consequence for his conduct. He lost his life for his foolishness. We're here today, and for the next few weeks, 2 weeks, to bring accountability to Michael Slager for his choices, for his decision to go too far, for his decision to let his sense of authority get the better of him, for his decision to shoot an unarmed man in the back 5 times, to try to shoot him 8 times. The first shot, you'll hear evidence, the first shot was from about me to around about here. The first shot. And it wasn't like this, and it wasn't like this. Walter Scott had his back turned. And when the last shot was fired, we're talking about right here. And again, it wasn't like this. It was like this. An unarmed man shot at 8 times. 8 times. Ladies and gentlemen, you heard the judge, and the charge in this case is murder. And I'm going to talk to you about murder and what that means. Because you need to understand, and the judge will give you a much deeper understanding and more details about the elements of murder. But so you can know what you need to be thinking about as you hear the testimony. I want to talk to you about those elements. Murder is the unlawful killing of another person with malice aforethought. We have so many screens now that let me stand over here. The unlawful killing of another person with malice aforethought. Now, what I want you to notice is, it's not called murder in the first degree. We don't have degrees of murder in South Carolina. So when you hear that kind of jargon, was it murder 1, was it murder 2? We don't have that. This is the simplest statute that we have in our books. Probably one of the shortest. The unlawful killing of another person with malice aforethought. Notice that premeditation is not an element. Now we have malice aforethought, and I'm going to talk a little more about that. But we don't have this notion of premeditation that someone has to have been planning out their actions for days, weeks, months. Malice is not a character trait. This isn't about whether or not someone's a good person or a bad person. Proving malice is about us proving a thought or a feeling that represents a meanness, a malignancy, wrong thought, ill will. It can be hatefulness, but when two people don't even know each other, that doesn't necessarily conjure up feelings of hate. But ill will, an extreme indifference to human life. So you have this malice concept, this ill will, malignancy, meanness, that must develop sometime before the fatal blow, sometime before the shot is fired. Malice. It can be a split second. It can be a minute. Of course, it can be days and weeks. But under our murder statute, we have to prove malice aforethought, that this defendant had malice in his head at some point before firing shots. That's what's required. And to do that, how do we do that? How do you prove what's in someone's head? You do that by showing their actions, by showing the facts. So let's talk some about the facts that you're going to hear from the testimony from that witness stand. It was April 4th, Saturday. It was Easter weekend. We're in the Remount Road, Rivers Avenue area. A guy named Pierre Fulton, who worked with Walter Scott, and he were together that morning, between 8:30 and 9:30 that morning. They had gone to a church to get groceries and had dropped groceries off at Pierre's house and were on their way back to Walter Scott's house. Now, Walter was in his new car, and his new car was a 1991 Mercedes. So his car was 20-something years old, but it was new to him and he was proud of it. And on their way from Pierre's house back to Walter's house, they get stopped. And they get stopped by Michael Slager. And this is a screenshot from Michael Slager's dash cam video. And you can see that the third tail light, the one in the center, the cyclops light, isn't working. Two brake lights are working, but the cyclops light is not working. It's not that it's broken, it's not working. It's not that there was bad driving, not that there was speeding, not that there was no blinker, not that there was a failure to yield the right of way. This car that was new to Walter Scott didn't have the third tail light, and Michael Slager pulled him over. And everything was going swimmingly. Everything was fine. You'll see from the dash cam video and the audio that Mr. Slager walked up, asked Walter Scott for his driver's license. You might be able to see it in Officer Slager's hand there. Mr. Scott gave him his driver's license, explained to him what the situation with the car was. But Walter Scott knew something that Michael Slager never did. He knew that when that license got run through the system, that he was going to debtor's prison. What do I mean by that? He had a family court child support warrant for his two children with his ex-wife. And that when that was found out, he'd be going to jail. Michael Slager didn't know that because he never had a chance to run the driver's license before Walter Scott took off running. Something he should not have done. And it was ironic that he's running because of his child support warrant for one child who's about college age, who was living with him at the time. The other child had spent the night with him that night. But he takes off, and I told you that we're in the area of rivers and remounts. So let me just show you on this map. This is Rivers Avenue, right here. This is Remount Road. The stop was right here in this advanced auto parts. Walter Scott runs from that parking lot down the road to what you might here call the yellow brick road. There's a yellow pathway. It's an asphalt road that's painted yellow. And once they get there, there is a struggle. And the defendant claimed when he has talked about this to his colleagues that Walter Scott grabbed his taser and that Walter Scott was coming at him. And that's what caused the shooting. So you need to understand a little bit about a taser. You probably know what a taser is, but whether or not you have the nuts and bolts, you'll hear more about how they operate. This is a picture of a taser like Officer Slager's. On this end, where this red circle is, this right here, that's a cartridge. This comes on and off, that cartridge. When the taser is fired, those doors blast off. You can see these wires connected to these two probes. All this confetti has serial numbers on it to match the cartridge to what was fired. So what happens with the taser is when those two probes go out and they hit someone and basically stab somebody from two different points, it sends a jolt like you can't believe through the body, and it causes them to block up completely, to lose total control and drop. So what had happened as Walter Scott was running away is that Michael Slager fired the taser at him. The first taser misses because you got to have the two prongs in to make that full circuit of electricity to jolt him. He reloads, takes one cartridge off, reloads, puts another one on, shoots the probes. This time he gets him. Two probes in the back. Walter Scott is down. Those tasers, those jolts go in 5-second increments. Walter Scott got 2 jolts out of that. First from the initial, and then the trigger pulled again to keep him incapacitated. It is incapacitating. The other way a taser works, and this is going to be important too, is if you take that cartridge off, take the cartridge off, you can create a current there and do what's called drive stunning. And that is different than the taser probes. Because drive stunning only hurts where you're hit. Whereas when you get hit with the probes and the electricity makes that big current through the body, it's incapacitating. This is pain compliance. And Michael Slager used pain compliance on Walter Scott, who had run from an unoperating taillight, third taillight. He got drive stunned several times. So, as you might imagine, and you will see from the evidence, that when someone is being drive stunned, the natural reaction is to go for it, to try to get that pain away. So what do we have? We've got Walter Scott's DNA on the taser. We don't know exactly from where, but it would make sense, and it would be reasonable for you to think, and the evidence will show that when he's drive stunned, his DNA can get on the taser. When he undoubtedly tried to get that taser away from him, his DNA could be on the taser. So there is DNA on the taser. And the question of whether or not Walter Scott ever took possession of that taser doesn't go to guilty or not guilty. It goes to provocation And provocation is not the same as justification. Walter Scott getting that taser, you may think, provoked Officer Slager. And it may have provoked him, but it didn't justify it. Because again, that taser at that point was in drive stun mode. And the evidence will show you once again that drive stunning means there has to be hand to hand. It has to be taser directly touching the body. And guess what? The evidence will show you from here to there, 17 feet, that kind of taser is not a danger anymore. And it surely isn't a danger at 35 feet or at 50 feet where Walter Scott died. You will hear, and the judge will talk to you, I suspect, because there will be an issue in the case about this provocation. Because we do have another kind of intentional killing called voluntary manslaughter. And that is a killing that occurs in the heat of passion upon sufficient legal provocation. I call it for short a killing under the influence of emotion, under the influence of legal provocation. Whether or not Walter Scott ever had possession of that taser, what you have to remember and what the evidence will show you, that the taser was not a danger, and what the evidence will show you very crystally clear is that in fact Walter Scott did not have the taser when he ran away. He didn't have the taser in his hand. The taser was on the ground. Was it in his hands? You also hear testimony about oaths. You just took an oath. We've all taken oaths to be here. What you will see is that Michael Slager had the duty and the privilege of protecting and serving. He wore the badge, and thank goodness for all of those who do wear the badge, because we couldn't be here doing what we're doing today without it. They keep us safe. They keep us safe. But with that duty came great responsibility, and when Walter Scott ran, and when he resisted, he should have been prosecuted for it. He shouldn't have been killed over it. Michael Slager had the duty of protecting Walter Scott and people like him, even from themselves, even from their own foolishness. That is part of their responsibility. He also had the duty. Michael Slager also had the duty to tell the truth. And what the evidence will show you is that after this happened, his first instinct was to lie. Because what Michael Slager didn't know in the days after all this, something you all know and we all know now, he didn't know somebody was watching him. He surely didn't know that somebody was also videotaping. And so when he talked to his colleagues out at the scene, and when he talked to Slav after they gave him days to recoup, he lied. First off, he said this was self-defense. Walter Scott was coming at him with the taser, and as he turned away, he shot him. Everybody who talked to understood that. Everybody he talked to believed that. Walter Scott was coming at me. He grabbed my taser. I shot him as he turned. He didn't know that that could be disproven by the video. And then, when he said Walter Scott ran away with my taser, he didn't know that we could show that that wasn't true. He didn't know that we would show that. And then, when he said that that taser was found somewhere between where he shot and where Walter Scott landed, he didn't know that we would be able to show that taser was 12 feet behind him. His first instinct after those shots were fired and he cuffs a dead Walter Scott was to stage. Was to stage the scene. Because the next thing that happened after he cuffed Walter Scott is he runs back and gets that taser from behind where he was standing, not to consolidate his gear, not to make sure it was safe. Because if you do that, you pick it up and you put it in your holster, just like you do your firearm. He picked it up. He walked over to a dead Walter Scott and threw it down right beside him. And it was only when the evidence will show you, he realizes that he's now being watched, that he picks up the taser that he is discovered beside Walter Scott. Those are the reasons that Michael Slager is charged with murder. I am getting ready to sit down now. And I want to remind you, when you're thinking about malice, to remember Michael Slager's first instinct wasn't to give CPR. It wasn't to give first aid. It was to stage. In the next few days and weeks, we ask you to not let anybody convince you that you don't see what your eyes tell you to see. And we submit to you that when all the evidence is in, you are going to know that what Michael Slager did to Walter Scott was wrong. It was flat out wrong. And you will know that he is guilty beyond a reasonable doubt.
Ladies and gentlemen, we'll take a few minutes break. Please go to the jury room. Please do not discuss the case. We'll take about 5 minutes or so.